Lou?
Good morning.
Hello, good morning. Yeah.
Is that everyone, Ms. Truitt? All right, thank you. You ready to go on the record, Ms. Siebert? Good morning. It is 9:07 on October 29th, 2021, and today's proceedings before the Board of Disciplinary Appeals are called to order. In furtherance of the Supreme Court of Texas's emergency orders regarding COVID-19 and consistent with Part 7 of the Texas Rules of Disciplinary Procedure, the Board of Disciplinary Appeals will hear today's cases through remote connection. If you get disconnected, please know that we will pause the proceedings and allow you to regain connection. If you have any technical difficulties, the BODA staff can be reached by phone. Ms. Truitt will put that information in the chat, and so you can reach her if necessary. We ask all participants to conduct themselves just as if they were in person in the Texas Supreme Court courtroom. I'll begin today's proceedings by introducing the board, and I ask that each board member kind of raise a hand and give a wave as they're introduced. I'm Kelly Hinson from Dallas, and I'm chair of the board. Mike Gross from San Antonio is vice chair. The other board members are Guy Choate, San Angelo, he's off screen this morning. Joe Cleveland from Fort Worth. Rudy Mateer, Pflugerville. Bill Ogden, Houston. Cindy Tisdale, Granbury. And we are pleased to announce the board has 3 new members who were recently appointed by the Texas Supreme Court joining us this morning. Jason Boatwright from Dallas. David Iglesias from Tyler. And W.C. Kirkendall from Seguin. Nancy Stone from Amarillo and Jessica Barger from Houston are not present at today's proceedings and will not participate in the decisions. 6 members of the board constitute a quorum, and we have a quorum this morning. The board instructed parties and counsel to submit electronic files of any potential exhibits in advance of this morning's hearings. Please note that all exhibits must still be offered into evidence and admitted by the chair in order to be considered part of the record. If you wish to offer an exhibit that has not been submitted in advance, you must request leave to do so. You may request authorization to use the screen sharing function to display exhibits that have been admitted. Council, if you have any witnesses on the Zoom call, I don't think I see any, but we will ask that you ensure compliance with the rule, and we will invoke the rule in our virtual courtroom. So if any witnesses are present, we will excuse them to the waiting room before proceedings begin. Any pro se parties wishing to give testimony as a witness must be sworn in, or else their comments will be regarded as argument rather than evidence. We have a court reporter present, and she will make the official record of today's proceedings. We will also record today's proceedings and post to our website. Any other recording is prohibited. All right, let's call this morning's docket. I note first that the following cases have been removed from today's docket. Case number 61628, In re Talion Kyle Taylor, a compulsory discipline matter, has been removed from today's docket in response to the commission's request. Case number 65862, In re John O'Neill Green, a compulsory discipline matter, has been continued to the board's en banc hearings on January 28, 2022. Case number 65866, In re David Allen Kruger, a compulsory discipline matter, has been continued to the board's en banc hearings on January 28th. Case number 65865, In re Wesley Lyndon Clark, a reciprocal discipline matter, has been continued to the board's en banc hearings on January 28th. And finally, case number 65861, in re Alfonso Canard Jr., a reciprocal discipline case, has been continued to the board's en banc hearings on January 28th. I'll begin by calling the docket, and then we will make a decision on the order in which to hear today's cases. The first case on today's docket is case number 65570 in the matter of Carl B. Duke Jr., a reciprocal discipline case. Is the commission ready? I'm sorry.
I'm present here, Your Honor.
All right, thank you. Is the commission ready?
Yes, ma'am. This is Luis Marin on behalf of the commission. I'm ready.
Said the pixels were all wrong. Not the first case, so if I get cut off, I can get back in.
Mr. Mata, could you mute yourself while you figure out your technical issues, and then we'll be with you in just a moment.
Were you able to hear me, Madam Chair?
Yes, Mr. Marin,
Okay.
I did. Will you be calling any witnesses in?
No, ma'am.
Okay, thank you. Mr. Duke, are you ready to proceed this morning?
Yes, ma'am, I am.
What is your time estimate?
The only evidence I'm going to have will be whatever questions that you ask me under oath, as well as I have information that I would like to keep the record open. I forgot that I'd had a certificate of completion of a pretrial intervention from Hillard Moore, the DA over in East Baton Rouge, where all this occurred. And I also had a letter from him about that completion of the pretrial intervention. I think I had sent in the bills of information showing that they had been dismissed, that I asked.
I don't know
BP
they
to the
allow
record.
speakers, but I don't know if they can hear me.
So just, I guess my testimony and the bills of information showing that they were dismissed, and I'd like to hold the
Well, I
record
can hear it
open
here.
to get in
No,
the
the screen is not full, but they can hear me.
the information from the DA's office.
So how much time do you believe you'll need for that, Mr. Duke?
I actually took pictures of
Okay.
that this morning when I found them, and I tried to send them to Mr. Marin and some others, but I'm not sure it was when I found them. I'm not sure if it got to them yet through their email. So,
Okay, will you be calling any witnesses besides yourself?
no, ma'am, just me.
All right, Mr. Bruno, case number 65864 in the matter of Jason Mario Bruno, a reciprocal discipline case. Is the commission ready?
Yes, ma'am. The commission's ready. I'm gonna present the case, and also my colleague here, Ms. Judith DeBerry, is gonna address the board regarding Mr. Bruno's defenses.
Okay. What is your time estimate, Mr. Marin?
For the first case, Mr. Duke, no more than 5 minutes. The presentation on Bruno's, I mean, of course, we have some motions pending, but on the presentation, no more than 5 or 10 minutes. If we go ahead and discuss the motion to dismiss, that would have probably 10 more minutes, and in the arguments, 10 more. So, I mean, at the very end, it's no more than an hour for the whole case.
Okay. Will you be calling any witnesses?
No, ma'am.
All right, thank you. Mr. Bruno, are you present?
Yes,
Are you ready to proceed this morning?
I am.
The board has received your answer and your motion to dismiss. The motion to dismiss is denied, so we will move forward with the hearing. With that in mind, what is your time estimate for presentation this morning?
All I have, I'm going to offer my exhibits, which I submitted already with my materials, and then the only witness I would have are my own statements, so maybe 20 minutes, and not including any questions.
Okay, thank you. The final case is case number 64651, Mario A. Mata versus Commission for Lawyer Discipline, which is an evidentiary appeal. Is the appellant present? Mr. Mata? I believe you are muted now, so could you unmute and announce? We'll let the record reflect. Oh, there he is. Okay. Mr. Mata, are you ready to proceed this morning?
Yes, ma'am.
Okay. And is the commission ready?
Yes, Madam Chair, this is Douglas Lang appearing for the commission. We're ready to proceed.
Okay, thank you. That completes the docket call. We're going to call the Mata case first, followed by Duke, and then Bruno. So we'll excuse all the non-participants into the waiting room, and only the parties and counsel for the Mata case will remain. This will take probably at least 40 minutes. So if you want to get a cup of coffee and join us back in 30 or 40 minutes, it'll probably be that long before we get back to you.
Okay, thank you.
Thank you.
It would be best if I had a speaker.
It looks like we only have the participants for the Mata argument present in the courtroom at this time. Counsel, you'll each have 20 minutes to present your argument. Mr. Mata, how much time would you like to reserve for your rebuttal?
I'd like to keep it at 20 minutes, but there are some issues that were a surprise in the evidentiary hearing that were in my favor. So I think it'll take 30 minutes.
Well, we have a 20-minute time limit unless the board has questions. And so you can reserve some of those minutes for rebuttal, but those will be deducted from your 20 minutes.
Thank you.
How many minutes would you like to reserve for rebuttal?
10.
Okay. That means you'll have 10 minutes to begin. We have a timer that you should be able to see in one of the Zoom boxes. Can you see that, Mr. Mata? There's a box that says Blue Sky Timer.
I don't see it. Share screen, more, leave. Don't want to do that.
It's
View.
among the boxes with everyone's pictures. There's one that says Blue Sky Timer. Has a blue background. That's where the timer will appear, but I will give you a 3-minute warning and then let you know when your time is through. Okay?
By the way, I don't know if it's relevant. I've never done this. In fact, I've never done the trial. I don't see the other participants on the board. Are they going to be there?
The board is all here and we are on the screen if you are in the gallery view. And Mr. Lang, representing the commission, is also present on the screen.
Okay, my daughter's going to go get me some speakers to see if that helps because I can barely hear you. But this is what I do for doctor visits, although I've never done Zoom, so those speakers will hopefully help.
Okay, we can hear you, and so you may begin, you may proceed with your argument.
Thank you. May it please the board. My name is Mario Mata. I'm an attorney that graduated from University of Texas in November 1978. I've practiced several areas of law, board certified in commercial real estate. When I got to, when the bankruptcy code was amended, I didn't do any more bankruptcy code work. I did real estate work, but bluntly, I found that doing international and offshore trust work was far more beneficial. Now, I'm assuming, and you correct me if I'm wrong, that the members of the panel are not particularly well versed in offshore transactions, offshore trust, offshore companies, and why we do it. I think, would that be a fair assumption?
I'm not familiar with everyone's experience on the board, but go ahead and tell us whatever it is you think we need to know.
Well, it's an extremely complex matter because what we're doing is setting up a foreign trust in a foreign jurisdiction and having the assets of the trust be in Switzerland. The settlor beneficiary of the trust is typically the client. And during the process, I don't get involved in the funding of the trust because I don't have any authority to do that. I don't have, the people holding the assets in the United States are not going to take my word or authority to transfer those funds. So those funds are all transferred by Mr. Moser. Now, you might ask, and I'm always asked this question, so I'll volunteer it. Why do you have to go offshore? The reason is,
if I could interrupt, I just want to remind you that the legal issue in your appeal is whether the grievance is barred by the statute of limitations. So you may want to direct your comments to that legal argument, given the limited time.
okay, well, as you may know, I filed a motion to add to the evidence that was going to be presented here, several exhibits, multiple exhibits, actually just 3 exhibits, because of the fact that the commission had added those, which made me realize that maybe I should have done that. That motion was denied for the simple reason that the board felt that those documents were already part of the record. And therefore, there was no reason to supplement what was already in the record, which was just fine with me. In fact, I like the language that the Board of Disciplinary, that's the wrong denial. They denied it in any event because they felt that was on the record. But the main thing that is critical here is I try to underscore to appellate counsel that both at the evidentiary hearing and in my brief, there was no evidence that this infamous January bank statement of 2014 existed. The board has relied on that significantly and has never changed its position. And the reason it's so important to this case is because if the complainant had received that statement and that was his first opportunity to notice that the funds that he was expecting had not been transferred, were not there. However, I hinted in my brief that the filings of the commission had all made reference to this January 2014 statement, which of course would have made the grievance timely filed. But there is no January 2014 statement. And I know that just from experience from dealing with this bank, Vontobel Bank and Swiss American Advisors. So they went back and in my supplement, I pointed out the fact that the statements come in on a daily basis, I'm sorry, on a quarterly basis, and Mr. Moser claims that he did not realize that the $275,000 that he was looking for was not there. And he didn't realize that until he got his January 214 statement. There is no 2014 monthly bank statement. I get a copy of everything from the bank that that Mr. Moser gets, and I apologize, but I didn't realize I was going to go first. I thought I was going to go last, but the supplemental, the supplement to the record, which was accepted by BODA, made it clear, absolutely clear, that a third and fourth quarter investment statement had been filed. And
Mr. Mata, I'm sorry to interrupt you, sir. This is Michael Gross. I'm just curious if I could ask you, you've only got 2 minutes left on the clock. Why did you not raise statute of limitations below, sir?
because I'm not a litigator. In fact, most of my law is practicing foreign law.
Okay, what's your position today on the statute of limitations, Mr. Mata?
The statute of limitations expired because when the complainant received his third quarter, that period ended in September of 2013. And then there was a statement for 2014, the fourth quarter. And there is this reference to an January bank statement. And that's when he discovered that the funds were not there. But no, a statement was issued in the third quarter. And that's when he should have realized through due diligence that the funds were not there. There were other funds that were not there, tax funds, but they were not there. They were not there. And therefore, he should have realized when he got that third quarter statement that the funds were not there, and there was about $154,000 in tax money that was also not there. And the reason I didn't raise the statute of limitations because I'm not a litigator, sir, and I don't know the first thing about litigation. And I did not file an answer. And as you may or may not know, I cited court cases that specifically said that if an affirmative defense is not raised during the trial, then the defendant can raise those issues for the first time on appeal. Now, those are court cases, of course, but I have no reason to believe that they did not apply in this case.
Okay, Mr. Mata, your initial time is up, so we will let the commission have their 20 minutes, and then you'll have your rebuttal time.
Thank you.
Mr. Lang, you may proceed.
May it please the chair and the commission and the board. The point here, as Mr. Mata has finally addressed, is that he did not raise the statute of limitations, which he asserted in his brief. He did not raise it at all. He filed no answer. And during the course of the proceedings, at the panel, there was no hint of any point raised by Mr. Mata about the statute of limitations. I would also respectfully point out that the cases that have been cited by the appellant say nothing about the defendant being able to raise an affirmative defense on appeal for the first time. Contrary to that, the cases clearly say if there is not an issue raised as to the statute of limitations as an affirmative defense at the time of trial, the issue is not preserved and cannot be brought forward. Furthermore, there is an allegation in the brief that the matter was tried by consent. As I'm sure the board knows, but let me say it for the record, trial by consent is only evident where both parties have addressed the issue in the trial and the court has been fully aware that that issue is before the court. Now, the Pine Trail case, which we cited in our brief, makes it very clear what it takes. If not properly pleaded, but the issue is brought before the trial court by the active assistance of both parties, will be considered to have been properly raised to the trial court. There is no citation to the record by the appellant that occurred. There is nothing in the record on that. Therefore, the issue is not preserved, and respectfully, it should not be before the board as an issue at all. Under the substantial evidence rule, which is the standard for review in this matter, there is ample evidence, much more than a scintilla, that the appellant received $270,000 from Mr. Mosier, from Dr. Mosier. It was put into the appellant's IOLTA account with directions that it would be transferred to the Swiss bank, Vontobel, for the purpose of being part of the Cook Island Trust that Dr. Mosier had started. That money was put into the IOLTA account, but then over a period of time, it was put into the appellant's pocket. He violated his sacred trust as a lawyer, not only as counsel, his fiduciary duty, but also under Rule 1.14B to hold that money in trust. And he did not do so. He has never accounted for what he did with that money. He said nothing until Dr. Moser's lawyer, which is all in the record, made demand for the return of that money. He has not returned it to this day, nor has he accounted. So we respectfully request that on this record, the sanction of disbarment be upheld.
Mr. Lang, if I could interrupt, if the grievance that or the misconduct that was found against Mr. Mata was failure to return funds, when does a failure to return or a failure to act occur?
Well, it's ongoing at this very day. I mean, the demands were made in 2014 by counsel for Dr. Moser. The letters from counsel and the testimony of Dr. Moser's counsel is there. It's crystal clear. There were apparently, according to Dr. Moser's counsel, there were representations by the appellant that I'll give it back. I'll give it back. It's never been done to this day. There is no accounting that has been provided as required by the disciplinary rules. So even were the board to look at the issue of statute of limitations, it's an ongoing violation. But furthermore, the board, panel determines the credibility of the witnesses and the weight to give to the evidence. That's their providence. And they determined that when Dr. Moser said, I did not learn about this until I received the third quarter 2013 statement, and I saw that there was nothing that was deposited. Mr. Mata must have done something wrong, or he must have just not taken care of business. But mid-January 2014, when Dr. Moser said he received it, is certainly a period that is 4 years from there. He filed his grievance on January 2, 2018. So we are within the 4 years, even were one to assume that there was statute of limitations raised. The facts are there on the record, but in the alternative, of course, as I said, we have a situation where this is an ongoing violation. He has not returned the money. We have seen in the record that he used it and put it in his own pocket. The only issue raised was statute of limitations. And again, respectfully to the board, I say he did not raise it. The rules of civil procedure are incorporated into the Texas Rules of Disciplinary Procedure to the extent that they are not inconsistent with the procedural rules. And Rule 93 requires an affirmative defense to be raised, and it's raised by pleadings according to the case law. It was not there. And furthermore, as I pointed out early in this argument, it was not tried by consent, which was one of the issues raised by the appellant. There is no hint in the record of any suggestion that there is a statute of limitations problem.
Mr. Lang, this is Nick Gross. I'm sorry to interrupt. I had a question for you if I could, sir.
Yes, sir.
So do you agree that Mr. Moser, he saw the third quarter bank statement back in October 2013. Don't you think he should have discovered any possible misconduct by Mr. Mata at that time back in October 2013?
I don't think he's put on notice of that, Mr. Gross, and here's why. The SV case from the Supreme Court that we've cited makes it very clear when there is a fiduciary duty, the party that is wronged, to whom the fiduciary duty is to be accorded, is not under a strict scrutiny obligation. But once it does come to that person's attention that there's a problem, then he must raise it. Now, the third quarter statement showed, as the board will be aware by looking at the record, does not show a deposit. That third quarter statement goes through the end of September. The money was provided to Mr. Mata within the month prior to that. And it should not ring bells necessarily if one looks at that statement and says, well, it didn't show up here. Well, it must be coming. But certainly the year-end statement for that final quarter that shows a zero balance in that account, and it demonstrates the money was not transferred, that rang the bell. And that's when Dr. Moser proceeded to try to find out what is going on. And he got no answers for quite some time, never was told about where the money went, but we found out in the record it went into the appellant's pocket.
Mr. Lang, you said that on the trial by consent issue, that there's no indication in the record of the limitations issue. But on page 19 of the transcript in Ms. DeBerry's opening statement for the commission, doesn't she address the limitations issue at some length?
Well, I don't think it was ever addressed by being joined during the trial. The appellant didn't raise it. He didn't say anything about it. And there was no discussion during the trial of statute of limitations. And that is a classic requirement in any trial, that the party utter the words statute of limitations or talk about time barred or something to give the panel some idea of what was going on. But nevertheless, even were the board to consider this issue, the fact is that it wasn't raised, and credibility is judged by the panel at this point, and they give weight to the evidence that they believe is appropriate. It's their discretion. Now, when Dr. Moser said, I learned about this when I got that statement in mid-January 2014, they gave credit to that, and they made that determination. And there was no contest at that time in the evidence by the appellant about any issue with that testimony. So therefore, on the record, Madam Chair, on the record, we don't have the issue of statute of limitations raised. It's not tried by consent, and even assuming that the board looks at the statute of limitations, it's the panel that made the determination about the credibility of the testimony and the weight to give to it, and they did so. And they found that there was a violation, and they have judged in their discretion what the appropriate sanction was, which is disbarment.
Thank you, Mr. Lang. Do any other board members have questions for the commission?
I do. Mr. Lang, it's good to see you. Thanks for your clear brief and your clear argument. I want to bounce an idea off of you very quickly. I don't want to take up too much of our time here today with this, but I think it's pretty important, and I suspect it's right, but I want to hear your take on it. It has to do with limitations in jurisdiction. Usually limitations is a pleading requirement. The plaintiff has to plead certain causes of action by a certain time pursuant to Chapter 16 of the Civil Practice and Remedies Code. And the defendant has to plead limitations as an affirmative defense under Civil Procedure 94. But the limitations rule that governs this case, Texas Rule of Disciplinary Procedure 17.06, is not a pleading requirement like Chapter 16 of the Civil Practice and Remedies Code. It is something very different, I think. It seems like it's a time restriction on the power of the bar to discipline an attorney. The accused attorney cannot, by waiver or some other means, convert a restriction on the bar's power into an expansion of the bar's power. I think only the Supreme Court can do that, and then only through a rule change. So it seems to me that limitations here is not something the accused attorney can waive. It's about the power of an adjudicator to resolve a case. It seems jurisdictional to me, again, because of the different basis for limitations. Chapter 16, in the case of most cases, Rule 17.06 here. Again, 17.06 is a restriction on the bar's power to discipline an attorney rather than a pleading requirement that's placed on plaintiff in the first instance and a defendant as an affirmative defense. What do you think about that?
Well, thank you for the question, Mr. Boatwright. There is jurisdiction on this record were we to look at it on that basis, because the time when Dr. Moser said that he first learned about the issue was mid-January 2014. That's the only testimony in the record about when that came to his attention. The grievance was filed January 2, 2018, within the 4 years. So on this record, on the facts, there is no jurisdictional issue.
Any other questions for the commission?
I'd like a point, 2 points, just to only take 1 minute.
Mr. Mata, let me just make sure no one has any other questions for the commission.
Thank you.
Yep. Mr. Lang, would you like to add anything else?
No, ma'am, I appreciate very much the opportunity to present, and I will await the response of the appellant.
Thank you. Thank you for your briefing and argument. Ms. Truitt, if we could reset the clock for 10 minutes. Mr. Mata, you have 10 minutes in rebuttal.
One of the principal mistakes and something that was shot down at the evidentiary committee or panel was I try to bring up the fact that this was not Dr. Moser's funds. The panel didn't want to hear about it. They didn't want to hear about it. They said it's his money. Much to my shock, when the judgment of disbarment was issued, it was made payable to his mother's trust, which is the Moser Family Trust, which has got one principal beneficiary and about 8 contingent beneficiaries. My job, although I didn't know it at the time, is that he expected a challenge to his withdrawal of the funds from that trust. And he wanted to make sure that he put it in a form where it could be protected from the family. But the fact of the matter is that I realized that issue also when, as far as proper party, and he should have brought it as trustee when I thought of that issue, but I decided not to bring it. And yet, despite the fact that the evidentiary panel didn't want to hear it, they got it right. They decided that it did belong to Mrs. Moser's trust. Secondly, I filed a motion which was granted to supplement the record because the order in which these statements from the third and fourth quarter from Von Tobel Bank just simply did not make sense. As a matter of fact, the cover sheet starts out November 30th, 2013, and then it starts talking about December 31st, created on January 1, which would clearly make the filing on a timely basis. Then you look at the back of the commission's own documents, they have another quarter named September 30th, 2013, in which they finally put in the 2013, the third quarter statements, but they're out of order. And I immediately noticed that the purpose of my supplemental record is to place these documents in the correct chronological and numeric order that they were issued by Von Tobel Bank for the quarter ending September 30th. And it's very, I mean, it's in the record, except that mine, it just says it's a cover sheet September 30th, 2013. And it starts out with the activity of December 31st. By that time, it's problematic, especially, and I think I implied in my brief, where is this January 2014 bank statement? The commission has never produced it, and I know why they haven't produced it, because it doesn't exist. It doesn't exist.
The evidence, as I understand it, or the argument, is that he received the fourth quarter statement in mid-January, that there's not a January statement.
Yes, but if he received the third quarter statement, that would have been for the period ending September 30th. And that he was close, but he would have missed the statute of limitations limitations by that time, because I think in the commission's petition, they conceded the point that it takes about 10 days to get those things mailed. So he would have had it on or around October 10, by which time it was already too late for the filing of a grievance. And I frankly did not, especially since I'm not a litigator, did not bring up the fact that he filed it in the wrong capacity. He filed it in an individual capacity, and if you look at his grievance, so he could go into his personal trust, but the evidentiary panel found that that money belonged to his mother's trust, and he should have not been taking it out of that trust. That trust has now been depleted. And I strongly encourage the party and the panel to look at the documents that the panel, or I'm sorry, well, yes, the panel allowed me to supplement the record with. I lost you.
I'm muted, sorry. I said that we will review the record. Do any board members have any questions for Mr. Mata?
Mr. Mata, this is David Iglesias. You had mentioned, or at least as I understood it, you had mentioned in your previous argument that you have reviewed cases that stand for the proposition that the statute of limitations can be raised for the first time on appeal. First of all, did I understand that correctly? And second of all, if so, what is the best case for that proposition that the statute of limitations can be raised for the first time on appeal in a case like that?
I based my conclusions based on the the Texas Supreme Court of Texas decision in Rourke versus Stallworth Oil that I do recite in my brief. And I went right for the heart of it. And basically it said, if you don't raise the issue and the petitioner does nothing about it, then they have waived the right to prevent the respondent from bringing it up at appeal. And this is particularly important because it could have easily, with one sentence and the judgment, been resolved. As you typically see, I'm not a litigator, but I've seen enough judgments to say all of the relief not granted herein is hereby denied. Well, it could have said, and the state bar may actually want to think about this, it could have all say all relief, including affirmative defenses, are hereby denied, but they didn't do that. And that's why the Rourke case makes it very clear, and that's a Texas Supreme Court case, that if a respondent does not bring up the affirmative defense and the petitioner doesn't do anything about it, then the respondent has an opportunity to bring it up for the very first time on appeal.
Thank you, Mr. Mata. Thank you for your argument. If you don't have anything further, then the board will take this matter under advisement.
Thank you.
Thank you. You are excused.
Thank you.
Thank you very much.
Do any of the board members need a break before we launch into the next case? All right. Ms. Truitt, can you bring in the parties for the Duke matter?
This is Matt. Jackie's internet connection, I think, had an issue, so I've got the host duties. And so which was the matter you want to go next?
Mr. Duke.
Mr. Duke.
We will now call the case number 65570 in the matter of Carl B. Duke Jr. Mr. Marine is appearing for the commission and Mr. Duke is appearing pro se. Counsel, would you state your appearances for the record, please?
This is Luis Marin for the Commission of Lawyer Discipline.
My name is Carl Duke, appearing pro se.
Thank you. Mr. Duke, we received the email that you sent on Wednesday and are treating that as an answer. Do you anticipate filing a more formal answer, or would you like us to consider that email to be your answer?
I would just ask that the board consider that as my answer. I mean, there's no need for me to file pleadings when they're going to say the same thing. I was having a terrible marital breakup and did what I thought was the right thing. Got some help from the doctor, and the medication I was on didn't agree with me running around and drinking at night because I wasn't feeling good, and all of it led up to a terrible incident that, you know, now I'm having to address. So
Understood. Thank you, sir.
Thank you.
Mr. Marine, would you like to make a brief opening statement before we begin with the evidentiary portion?
Yes, ma'am. I might just say the preliminary facts of this case and then go just ahead and present the exhibits.
Okay, if you want to give a 2-minute summary, and then we'll circle back to you for the evidence, or if you want to just wait and we can do it all at once, it's up to you.
I mean, it's so simple. We can just wait and I'll do both right away.
Okay, then you may proceed.
Thank you. May please the board. This is a reciprocal disciplinary action brought pursuant to Part 9 of the Texas Rules of Disciplinary Procedure based on Carl B. Duke Jr.'s professional misconduct and suspension in the state of Louisiana. The commission is ready to present this case. The preliminary matters are: a first amended petition for reciprocal discipline was filed with the Board of Disciplinary Appeals on September 8, 2021. An order to show cause was signed on September 10, 2021, requiring respondent to show cause within 30 days of the order why identical discipline should not be imposed. Respondent was personally served with the first amended petition and order to show cause on September 29, 2021 by Marshall Akin from the Gillespie County Constable Precinct 4. Proof of service has been on file with the board since October 12, 2021. In terms of our reciprocal petition, on or about February 17, 2021, a revised joint petition for consent discipline pursuant to Rule 9, Section 20, which includes a revised joint memorandum in support of petition for discipline and consent pursuant to Rule 9, Section 20, and stipulations of fact in support of joint petition for discipline on consent, was filed in the Supreme Court of Louisiana in a matter styled in Re Confidential Party Docket Number 2020-B-1272. On or about February 17, 2021, excuse me, an order per curiam was entered by the Supreme Court of the state of Louisiana in a matter styled in Re Carl Binus Duke Jr. number 2020-B-1272, stating, and I quote, respondent was arrested in 2 alcohol-related incidents. Following the filing of formal charges, respondent and the Office of the Chief Disciplinary Counsel submitted a joint petition for consent discipline. Having reviewed the petition, it is ordered that the petition for consent discipline be accepted and that Carl Binus Duke Jr. Louisiana Bar Roll number 25655 be and he hereby is suspended from the practice of law for a period of 2 years, with all but 1 year and 1 day deferred. This suspension shall be retroactive to July 31st, 2019, the date of respondent's interim suspension. In section 6 of the revised joint petition for discipline, respondent admitted to having violated the following Louisiana rules. 8.4b, that's equivalent to Texas 8.04A2, and 8.4A, equivalent to Texas 8.04A1. At this time, Madam Chair, I'd like to offer the following exhibits, which I have mentioned. Exhibit 1, a certified copy of revised joint petition for consent discipline pursuant to Rule 9, Section 20, entered February 17, 2021. Exhibit 2, a certified copy of an order per curiam entered on February 17, 2021 by the Supreme Court of the State of Louisiana in matter styled in Ray Carl Vinus Duke Jr., number 2020-B-1272. And Exhibit 3, original certificate from Blake Hawthorne, clerk of the Supreme Court of Texas, dated October 11, 2021, which indicates that respondent is licensed and authorized to practice law in the state of Texas, but it's also claiming an MCLE non-practicing exemption. Those are the exhibits we propose to be accepted by the panel, by the board.
Mr. Duke, do you have any objection to the admission of those exhibits?
No objections, Your Honor.
Okay, the exhibits are admitted.
At this time, Madam Chair, the commission would seek suspension as reciprocal discipline pursuant to Part 9 of the Texas Rules of Disciplinary Procedure.
Mr. Murray, what were the equivalent Texas rules that you cited?
Yes, it was 804A2 and 804A1. Let me just get them real quick.
Mr. Marine, would the alcohol-related offenses that Mr. Duke was convicted of constitute violations of 8.04A2 in Texas?
Just give me a sec. Well, actually, the decision of the Supreme Court of Louisiana actually found him in violation of their 804B and 804A, and they say those rules says it is professional misconduct for a lawyer to commit a criminal act, especially one that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. That rule from the Louisiana bar is equivalent to our 804A2, commit a serious crime or commit any other criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. So it's practically the same ruling. On the other one, 804A, the Louisiana rule says it is professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct, knowingly assist or induce another to do so, or do so through the acts of another. We contend that this is practically ad verbatim rule 804A1 of our rules that say a lawyer shall not violate these rules, knowingly assist or induce another to do so, or do so through the acts of another, whether or not the violation occurred in the course of a client-lawyer relationship.
And So my question, Mr. Marine, was, are the offenses that Mr. Duke was convicted of, would those constitute violations of our 8.04 A1 or A2 under the Texas rules?
Yes, ma'am. That's the position of the commission, yes.
Do any other board members have questions for the commission at this time?
Yes, Mr. Byrd, why is that?
I'm sorry?
Why are you saying, why is it the commission's position that the crime that Mr. Duke was convicted of would qualify as a disciplinary matter under 8.04 A1 or A2?
Well, actually, at the Texas bar, we do not relitigate cases that were actually litigated in Louisiana. We have actually the prima facie evidence that in Louisiana, he was actually found in violation of these rules. We actually saw that there's an analogous rule here in Texas, and that's why we're bringing this case up to this board. It is up to the board to decide whether his sanction in the state of Louisiana should be sanctioned as well in our state.
Would that be in the nature of a grave injustice defense?
In those cases, we don't have any opinion on that other than complying with our requirement to bring those cases to you as a board. We are pretty different of the decision you may make on this case.
Okay, thank you.
Sure.
Mr. Breen, Michael Gross, a couple of questions for you, sir. Is it the commission's position under 8.04 A2 that this is a serious crime, even though it's a DWI?
No, it's not, sir. We
Okay.
would actually go to the second part of the rule. That's
Okay. That it's a
Yes.
criminal act that adversely affects the
Yes.
lawyer's honesty, trustworthiness, or fitness?
Yes, sir. And that's because the Louisiana trier actually found that. So we're just conveying a resolution, a finding of misconduct in another jurisdiction to you as a board.
Well, of course, there's defenses, right, on the disciplinary procedure, right, under 9.04, right?
And that's for Mr. Dukes to raise.
Well, yeah, but and that's true. But the question I think Mr. Cleveland was getting at, and I too, is it the commission's position that, regardless of what Louisiana held, is it the commission's position or 8.04 A2 that a DWI adversely reflects the lawyer's honesty?
Well, I cannot talk about what the commission's positions regarding that public policy issue would be. I can tell you that on my personal opinion as a lawyer in the Commission for Lawyer Discipline, I would actually not uphold this as I would not actually pursue this if this case would have been filed in Texas. This being a reciprocal case, as the Office of the Chief Disciplinary Counsel, we have no option other than conveying the information to you so you can make a decision on the merits of the facts.
So if I understand you correctly, it's your position then that 8.04 A1 and 2 apply only because Louisiana found it applied under Louisiana's ethics rules, correct?
Yes, sir. And that's why we are conveying that information to you under Part 9 of our rules. Yes, absolutely, sir.
Okay. And then if we look at the defenses under 9.04, and I completely understand your position, that's up to Mr. Duke. What's the commission's position on whether or not, as Mr. Cleveland was just asking you, that it would be a grave injustice? I mean, you said that you all would not have pursued DWI if it had been, just Texas. But reciprocally speaking, what's your position on?
Well, if Mr. Duke decides to present that defense, we will not object. We'll just wait for your decision.
I see. So the commission's position then, if I understand you correctly, is that if Mr. Duke raises grave injustice, based on what you said today, the commission would not be opposed to that. Is that accurate?
No, and it is up to your discretion as a board to decide what's the outcome of this case. So be really respectful of what the board decides.
Yes, sir. And if we were to find grave injustice, then what would our options be as a board on this reciprocal, Mr. Marine?
Well, you can either lessen the sanction given to Mr. Duke or either dismiss the case at all.
Okay. Thank you very much, sir.
Absolutely. My pleasure.
Mr. Marine, I just have one question. Is the position of the commission, have you pursued such an action with anyone in Texas regarding DWI before?
Well, I'm pretty new here. I mean, I've been a lawyer since I'd say 2 weeks before the pandemic. So I haven't used my office a lot. But on a serious note, no, I don't think we have, on the recent years, we have filed any of these cases. Although we understand that in Part 9, the use of the word shall, it says that we don't have any options but to convey any information received of misconduct happening in another jurisdiction. So we actually recognize that it's your providence to decide on this case, it's not ours.
Okay, that makes perfect sense, Ms. Marine. And I was just thinking because you have Mr. Berry as a co-worker who's been quite established over there, and someone in that office may have conveyed to you if in fact this had been pursued at any other given time. But within your own knowledge and recollection, you haven't seen that to be the case. Is that correct?
Yeah, maybe Ms. DeBerry, who has a lot more experience, that we jump in and make a comment, but I don't think there's too much cases about it. You're mute, Judith.
You're still muted. There you go.
There you go. I was hitting the icon instead of the words. We have not pursued in a straight fax case anything for any allegations for a DWI. And to my knowledge, we haven't before the board either.
What about domestic violence?
We had one, and it was actually out of Louisiana. We had a reciprocal based on an attorney who had, and I can't remember the name now, I'm sorry, who had been convicted of assault family violence. And we brought that as a reciprocal case and the board declined to sanction the attorney.
Okay, thank you.
You're welcome.
Any other questions for the commission?
I have a question. What was the conduct for which he was sanctioned? Was it simply the DWI, or was it the DWI, the running from the police, the domestic violence, the whole panoply?
Are you asking on this case, on Mr.
Yeah,
Duke?
on Mr. Duke.
I mean, it was actually 4 different charges. If you go to the document submitted by Mr. Duke, actually, he just submitted one that that actually explicits the different charges filed. I'm actually reading from one of the 2 documents filed by Mr. Duke today, and it says charges operating a vehicle while intoxicated, first offense, maximum speed limit, aggravated flight from an officer, resisting an officer, and aggravated criminal damage to property. I mean,
I understand what he was charged with, but what was he sanctioned for?
Well, being those cases related to the same case, I would say it doesn't change my opinion about the case personally. I mean, because usually those are things that happen after the fact, and I understand Mr. Duke's position. Let me just review the document, because I think the issue here was the first charge. Hold on. Okay, I got them here. I apologize. I'm just opening the documents now. Okay. Okay, the charges as, because remember, this is a consent order. This is a consented order, which is an agreed order to us. And it makes reference to domestic abuse battery in violations of rule under the Baton Rouge and issues raising out from his arrest. And yes, it would be actually all the charges I mentioned you before that were part of the agreement signed by Mr. Duke. But then you can actually go to the second paragraph. And in the second paragraph, it says that all of the events were actually directly related to his alcohol consumption. I hope this responds to your question, Mr. Gross.
Thank you.
Mr. Marine, one quick question, sir. I saw in the stipulations of fact in support of joint petition for discipline on consent. I see paragraph 4, Roman numeral 4 of that the domestic charges were dismissed. Is that correct? I'm sorry, Roman numeral 5 of that. The domestic battery charges were dismissed and the subsequent criminal charges rising out of his DWI and related misconduct qualified for the felony diversion program. Is that what you're referring to, Mr. Marine?
Yes, that's correct, sir.
Thank you for clarifying it for me. I appreciate it.
Thank you. Thank you.
Thank you, Mr. Marine. Mr. Duke, you may
Yes,
proceed. I'm sorry. Before you begin, if you plan to give testimony, could I swear you in?
Yes, ma'am.
Raise your right hand, please. Do you solemnly swear or affirm under penalty of perjury that the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. And remember, if you want to admit any exhibits into the record, they must be formally admitted.
Okay, to try to get some of this preliminary out of the way, then I'll just, I'll invoke defense 9.04, the great injustice defense that I think I addressed in my email, basically. I would move to admit into evidence the DA pretrial intervention certificate and letter that I had. I think I got that submitted over the time frame while we were in break. I don't know if you have copies of it yet. The bills of information that have been filed. I'd like the board to take notice of the fact that during my past years of practice, I've never had any complaints made against me of any type whatsoever. I'll move to have omitted any statements made under oath by me and any other documentation or evidence that is in mitigation of further punishment in this matter. And then at this time, I would just state that I was going through a very terrible time in my life. I was not handling it well. I went to my doctor for help and she prescribed me some Lexapro and I started taking that as directed, but it did not do well for me. I was having auditory and hallucinatory episodes. I started trying to self-wean myself off of that, and I had not given up the drinking, which was how I was trying to make it through the evenings. Didn't work for me, obviously, but so that's basically what was happening during that time frame. So since then, I haven't had any alcohol consumption since August of 2019, August 2nd of 2019. I attend AA meetings. I am pulled randomly for blood and alcohol screening, as I agreed to do. And in fact, after we get off this Zoom meeting, I have a urine test that I have to go and do. And I think I've submitted information that shows I'm in compliance with all that with the Judges and Lawyers Assistance Program over in Louisiana. So I would ask that that be admitted into evidence. And I'd like it to be noted that when people are having problems in the legal profession, they're always told at all the continuing legal education programs, go see your doctor, go get some help. Well, I tried to, and it just didn't work out. It wound up, I just kept spiraling downhill until these incidents happened. But since then, I've tried to be in full compliance. I've tried to get things back straightened out, tried to get my life back. I've done nothing in my legal career except to help folks. Nobody's ever had an injury because of me practicing law. If you look, I think the comment was made about my conviction. I've never been convicted. Everything went on deferral, and I completed the programs to take care of that, and all the charges have been dismissed. I can't speak to Louisiana because at that time I was not able to put up a proper defense. I was just trying to get through it. But when you start talking about honesty and trustworthiness and fitness to practice law, those things go deeper than somebody suffering when their personal life's falling apart. My honesty's never been called into question. I've never converted clients' funds, not communicated with them. I've never done anything that is required of attorneys to successfully and skillfully represent their clients. So I've always done that. My trustworthiness never been called into question, and neither has my fitness to practice law. Now, my personal fitness at that time might be under question, but not my fitness to practice law. I just did not. I had a 30-year marriage with that I had a lot of emotion invested in, and when it fell apart, I just didn't handle it right, and that's how all this happened. But I've never done anything that would call into question my ability to be a good member of the legal community and serve clients. So I would like that to be noted and considered. And I would invoke any and all defenses, including the 9.04, and just ask that the board consider these things when they make their decision. That's all.
I'm glad that you have gotten help and that you seem to be getting your life back together and that you're doing better. That's comforting to see. I do have a couple of questions. Are you currently practicing law in Louisiana or Texas?
No, ma'am. I did. I was waiting to hear from Hillard Moore, the DA's office, and then Hurricane Ida hit the day that I was supposed to have court and get all these things dismissed so that I could go and do an appeal to Louisiana and get my license back active. And I've been on an inactive with Texas, and during this matter, I never tried to get my license active with Texas, even though I'm living in Texas now and I would like to practice. I was waiting to try to get this cleared up with Louisiana. So, but I haven't, just the timing of everything and including the hurricane between COVID and the hurricanes that closed down the legal system over in Louisiana, it threw everything back. And so I wasn't able to try to address those things before I got word from Texas. So.
And we need to be clear on exactly which exhibits you would like to have admitted so that Mr. Marine can have an opportunity to object. So what particular exhibits are you moving for admission?
I think there were 4 that I had submitted that have been filed with the board. Those 4 it would have been the certificate of completion of the pretrial intervention program, along with a letter from Hiller Moore. It would have been the 2 bills of information, and I believe that's it. I believe it's just those 4.
Mr. Marine, do you have any objection?
Oh, ma'am.
Okay, those exhibits are admitted.
Mr. Duke, you also mentioned something about the completion of your plan for the lawyers, judges. You mentioned something about another document. Was there another document that you wanted to have admitted?
Oh, I had a letter of reference from the judges and lawyers office. I'm not sure that has been filed. If it hasn't, I'd ask that the record be held open and let me get a photo image and submit that electronically to the board. It's from Jennifer Gross, who is the director of the program over there, that says I'm in full compliance. At the time she wrote the letter, I'd been drug tested 30 times, I think it was. And, you know, I always test negative because I don't do drugs and I don't drink alcohol. So.
We do have that. Mr. Marine, any objection to admission of the letter from the Judges and Lawyers Assistance Program?
No objections from the commission.
Okay.
I appreciate the board's assistance with that. It's the first time I've appeared before the board, so I'm not familiar with it. And I appreciate Mr. Marin's professional courtesies he's shown me up to this point. So appreciate it.
Mr. Duke, Mr. Duke, how much longer will you participate in that assistance program?
It was a 5-year program, and I've done more than 2 years.
Mr. Duke,
I have a question. The record says that you are that you moved to San Antonio to care for your parents. Are you still living in San Antonio, and how are you supporting yourself if you're not practicing law?
I had to sell a commercial piece of property that I owned, and after I split that with my wife, I've been living on that. I had to sell a home in North Louisiana and split the proceeds with her, and been living on that. I have a couple of trailers, enclosed trailers. I've been going and buying and selling things at flea markets and trade days in Fredericksburg. You know, doing whatever I can do to pay bills.
Mr. Duke, this is Michael Gross. I had a couple of questions for you, sir, about the pretrial intervention program.
Yes.
I see on the certificate, date of arrest was 7/20/19, and I see the completion date of your pretrial intervention 2 years later, 8/9/21. When did you enter the pretrial intervention program, real roughly?
It would have been like 1 year from the date of that the certificate shows the completion, because they didn't get me into it before then.
In Texas, to do pretrial intervention on a case, especially a felony case, you have to fill out an application, give character references, things like that, to convince the DA's office to let you do pretrial intervention. Did you do the same thing in Louisiana?
Well, I don't remember doing that, but I mean, I'm not unknown in the community. I'd worked for DOTD down there for 5 years in the transportation department. I'd prosecuted in North Louisiana for 5 years. You know, I was an assistant DA, so that's why on my letter I showed that, you know, I knew what happened. I did not do that. I did not. I ran from the police did not try to stop me, and I did not stop. I told my counselor up there, I could not tell you why. And that's why in my letter, she said, well, between that Lexapro and then your drinking, your brain had been hijacked. So, you know, I know you can't do those things. So they knew me in the community. They knew me for 20 years of practice. I've never had any problems. So these have been all personal problems that I couldn't handle. So.
What did you have to do as part of the pretrial intervention program? Were there random urinalyses and community service and things like that?
I did community service. In fact, I did the community service over in Fredericksburg. And if you care to contact the probation officers over there, they'll tell you I did a good job for them. They had me, anything they needed, I did it, and they were happy to have me there. And so I didn't even think to try to get anything from them, but you could contact them directly in Fredericksburg, Gillespie County probation office. So I had to pay monitoring fees to Hiller Moore's office, the DA in Baton Rouge. They accepted, they didn't double dip me on the urine screens and blood testing. They took the judges and lawyers that I have to do. And so they took those instead of having me do 2 different sets of drug analysis or, urine screens. The damage to property, I paid that off immediately in full. Everything they needed me to do, I took care of it quickly and timely, and had everything completed within like 30 to 60 days, but still had the year to run before they could dismiss them. So,
last question for you, Mr. Duke. In Texas, you'd be entitled to an expunction of all those records. Is it the same thing in Louisiana?
Yes, sir. They're going to be expunged. Everything should be in the process. The lawyer that I had over there helping me, they're in the process of expunging it, and the DWI will stay there for a period of 5 years. You can't, in Louisiana, you can't expunge a DWI until after 5 years. So,
thank you, sir.
Everything else will be. Thank you.
Marie, do you have any cross-examination of Mr. Duke?
Ma'am, I do not have a cross-examination, but I would like to add something to the record.
Okay. Mr. Duke, are you finished with your presentation?
Yes, ma'am. I think that's, I would just ask that, you consider any and all things that might mitigate against further punishment. I mean, it doesn't serve any purpose to keep beating a dead horse. I mean, I've almost given every pound of flesh I have, so I don't know what else to do.
Okay. Thank you, sir. Mr. Murray, your response?
Yes, ma'am. I would like to add, as an officer of the court, make this case clearer. Mr. Duke actually made some allegations about him not having prior disciplinary conduct. If you go to Exhibit 3 of the petitioner, you will actually see a certificate from the Supreme Court saying he does not have any disciplinary priors other than an administrative suspension. Other than that, I would actually convey the court that they might consider at the very end of Part 9. It says, if the Board of Disciplinary Appeals determines that one or more of the foregoing defenses have been established, it shall enter such orders as it deems necessary and appropriate. In that sense, you have ample discretion to work on this case. I would also mention the different mitigating factors on the sentencing guidelines that might be of application here. I can see from Mr. Duke's testimony and the documents presented herein that at least these are the mitigating factors we found. A, absence of a prior disciplinary record. B, absence of a dishonest or selfish motive. C, personal or emotional problems. D, timely good faith effort to make restitution or rectify consequences of misconduct. E, full and free disclosure to disciplinary authority or cooperative conduct during the proceedings. H, physical disability suffered by respondent at the time of the misconduct that caused or contributed to the misconduct. I, mental disability or chemical dependency, including alcoholism or drug abuse. K, imposition of other penalties or sanctions. Of course, we have the imposition that the sanctions entered by the other jurisdiction. And remorse, we get remorse from Mr. Duke's testimony. Other than that, I don't have anything more to say in this case, ma'am.
Thank you, Mr. Marine and Ms. DeBerry. We appreciate your candor in answering our questions with regard to this matter. Mr. Duke, any final words?
No, ma'am, I just appreciate the opportunity to talk to the board directly, and I do appreciate Mr. Martin's professional conduct in this matter and help. So.
Thank you. I appreciate both of your arguments, and the board will take this under advisement. You are excused, Mr. Duke.
Thank you, ma'am. Thank you.
Thank you.
Thank you.
The board will take a 10-minute break and then come back and hear the matter of Mr. Bruno. Matt or Jackie, could you let Mr. Bruno know that we'll start in about 10 minutes?
Will do.
All right. Thank you.
Thank you.
How are you, Kim?
Making it.
Yeah.
How are you?
I'm good. Do you like
Good.
working from your house? Or are you going to be glad to get back?
We're starting to open up, so I'm doing a lot more in person, and I'll be glad to be back in person.
Yeah. You're such a people person.
Yeah, I need that interaction.
Yeah.
And I'm sick of looking at myself on Zoom.
I know. Well, we miss seeing you.
I know, I miss y'all too. I think maybe I'll see you on January 28th.
Yeah, that's the plan at least.
Okay. I look forward to it.
Yeah, me too. Okay, looks like we've got everybody back. Should we bring Mr. Bruno in and get started? Mr. Bruno, I appreciate your patience. Are you ready to get started?
All right, how about now?
Yes, we can
Yes.
hear you.
Thank you.
Okay, let's go back on the record. We'll call now the case number 65864 in the matter of Jason Mario Bruno. Will the lawyers please state their appearances for the record?
This is Luis Marin for the commission. With me is Judith DeBerry, also for the commission.
Good morning. Jason Bruno is here pro se.
Thank you. Mr. Marine, would you like to begin with a brief opening statement, or would you prefer to just launch right into your presentation?
I can just go ahead because I'll present the case and then I'll defer to Ms. DeBerry to answer questions about the case. So I can just go ahead now.
Okay, you may proceed.
May it please the board. This is a reciprocal disciplinary action brought by the Commission for Lawyer Discipline pursuant to Part 9 of the Texas Rules of Disciplinary Procedure stemming from the Arizona Supreme Court's decision on October of 2020 to actively suspend respondent for 6 months, followed by a 2-year probated suspension upon finding that respondent Jason Mario Bruno committed personal misconduct. Today, we're requesting the board to consider the commission's petition for reciprocal discipline as well as respondent's response to the order to show cause. Other documents were pending, but were already considered by the board about the motion to dismiss. So I'll go directly to our petition. As I said before, I will present the case and submit the exhibits already attached to our petition. Ms. Judith DeBerry, also representing the commission, will address respondents' defenses and respond to any questions the board may have. As previously mentioned, the petition for reciprocal discipline in this case was filed with this board on September 8, 2021. An order to show cause was issued on September 10, 2021, requiring respondent to respond to the order and show this board why identical discipline should not be imposed. Respondent was personally served with the petition and order to show cause on September 21, 2021 by Thomas Gorgon, a private process server. Proof of service has been on file with the board since October 5, 2021. Respondent did file his response to order to show cause on October 21, 2021. In the underlying matter, a complaint was filed on March 18, 2019 with the Office of the Presiding Disciplinary Judge of the Supreme Court of Arizona in a matter styled in the matter of a member of the State Bar of Arizona, Jason Mario Bruno, bar number 023125, respondent in case number PDJ 2019-9011. Then on October 9, 2020, a decision order was entered by the presiding disciplinary judge that states in pertinent part that the court accepts the panel's findings that respondents' conduct violated ERs 3.3A3, 3.4A and D, and 8.4C and D. On October 15, 2020, a final judgment and order of suspension was entered by the presiding disciplinary judge, which suspended respondent for 6 months, followed by 2 years of probation. Madam Chair, at this time, I would like to offer the following exhibits. Exhibit 1, which is a certified copy of the complaint entered on or about March 18, 2019 before the presiding disciplinary judge of the Supreme Court of Arizona in the matter of a member of the State Bar of Arizona, Jason Mario Bruno, bar number 023125, respondent in case number PDJ 2019-9011. Exhibit 2 is a certified copy of the decision order entered on October 9, 2020 in the same matter. Exhibit 3, a certified copy of the and order of suspension entered on October 15, 2020 in the Arizona disciplinary case. Our last exhibit, Exhibit 4, is the original certificate from Blake Hawthorne, clerk of the Supreme Court of Texas, dated October 11, 2021, which indicates that respondent is licensed and authorized to practice law in the state of Texas.
Mr. Bruno, do you have any objections to exhibits 1 through 4?
I do not.
Exhibits 1 through 4 will be admitted. Thank you.
Thank you, ma'am. At this time, the commission seeks a partially probated suspension reciprocal discipline pursuant to Part 9 of the Texas Rules of Disciplinary Procedure. That would be 6 months active and 2 years probated.
Thank you, Mr. Marine. Mr. Bruno, you may proceed, and I'll caution you or remind you that this is an evidentiary proceeding. So if you wish to testify, I'll need to swear you in, and you'll need to formally move to admit any exhibits that you wish the board to consider.
Thank you, Madam Chairwoman. I would like to have my statements count as testimony. So if you would please swear me in.
Okay. Would you please raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony you will give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
And then, Madam Chairwoman, I'm not sure how you want me to do this because I have 33 exhibits. I could just offer them in a group numerically, or I can go through and kind of identify each one, whichever you would prefer.
Are these all exhibits you've previously submitted?
Yes.
Mr. Marine, would you like for him to go through them one by one, or do you have you reviewed them, and can you say if you have any objections?
We actually would not object at this time, the documents. Maybe as he goes talking about each document, if something comes up, I mean, I don't think something's gonna come up, but if something comes up, I will actually raise my objection.
Can I clarify just a minute, please? I think they were the exhibits that he attached to his response to the motion to show cause. Is that correct?
If you're speaking to me, ma'am, exhibits 1 to 32 were attached to my response to the order to show cause, and then I added a separate one, exhibit 33, which I submitted a couple days ago pursuant to the board's order and procedures.
Mr. Marin, do we have that 33? I haven't seen it.
That's why I just got those from the clerk of the board. I did not get anything else from the respondent.
We would not object to 1 to 33, but I would need to see 33 before we make a decision on that one.
Okay. Exhibits 1 through 32 are admitted. Do you have exhibit 33 available that you could show via screen share, or how can we, what's the best way?
I have it available. Whether I can show it to screen share is a whole different thing, but I will try.
Or if perhaps you could describe it, that would be good enough for the commission.
Sure, I think I can get it up. But what it is, it's the current Arizona rule related to the required disclosures pertaining to experts and the prohibited disclosures pertaining to experts. And I will, hold on, let me see if I could screen share it. Oh, it says the host is disabled screen sharing for me.
Okay, if it's a statute, we wouldn't object to it.
Okay, and I could give you the number if you bear with me for 1 second. Let me find it.
That would be helpful. Then I can pull it up if I need it.
It's it's actually Arizona Rule of Civil Procedure 26.
Okay, thank you.
Okay, exhibit 33 will be admitted. All right, Mr. Bruno, you may proceed.
Thank you. First of all, I appreciate everybody taking their time to be here today and considering the lengthy submittals that I filed with the board. I know that everybody, or I think that everybody has active practices, and essentially you're doing this on the side or volunteers. So I appreciate that. And I know you're spending significant time out of your day today. Even though the conduct alleged occurred in 2013 and 2014, it still remains important to me and my family that I be able to tell my side of the story. All I'm asking this board to do is look beyond the face of the actual disciplinary order and conduct an independent assessment of the actual evidence presented, the discovery requests, the stipulated facts, which I think were overlooked in the disciplinary order, and the applicable authority, including Arizona Disciplinary Rule 3.3, which relates to what kind of witness testimony needs to be clarified and the duties that are established thereunder. I would submit that if the record is reviewed objectively and in full, that there isn't evidence of any violation of any ethical rules. I didn't conceal any information in this case, and I have never done so in the hundreds of cases that I have handled in multiple jurisdictions dating back to 2004, and I would never do so. I have no previous disciplinary history in any of the 8 or 9 jurisdictions that I have been licensed dating back to 2014, either prior to or since the events giving rise to this petition that occurred in 2013 and 2014. I think when the case record is reviewed, it's a lengthy, hostile litigation that took, I think, about 6 or 7 years. I was placed in a difficult and unusual situation where I had an aggressive opposing counsel, and my client was disliked and was found to have concealed significant information in discovery. Unfortunately, what I think happened is that stigma basically fell to me unjustifiably. I think if you look in the record, you will see that there was an abnormal amount of discovery orders entered in this case, including because a special master was appointed to handle the voluminous discovery information. And I think if you see that I complied with every single order of the court entered in that case at great personal detriment. And I not only didn't conceal anything, but I think I went above and beyond to make sure that my opponent in that case received everything they asked for. I'll talk about it a little later, and it's in my briefings, but in this case, the court entered a forensic investigation of basically all of my clients' files and laptops. And because of privacy concerns and proprietary information concerns and attorney-client privilege concerns, the only one who got to see that stuff was me. So then I had the obligation to review that stuff, withhold anything I objected to, and produce the information to opposing counsel. Well, it's undisputed that I fully complied with that forensic investigation, but it literally took me about 256 hours of personal time for which I wasn't paid. And the information that I eventually turned over was deemed to be harmful to my client and used to dismiss his meritorious case probably 5 or 6 years into it. So I'm concerned by the allegation that I concealed something when I did the exact opposite. And because I complied with the court's rulings, which I had no hesitancy to do, by the way, my client's case was overlooked. And I don't want to belabor all of the arguments I made in my response, so I will try to be brief. I think there's a couple of important items that were overlooked in the disciplinary proceeding. I was accused of concealing a draft report of my expert in this case, but I was the one who actually produced the draft report. That was undisputed and stipulated to. The opposing counsel didn't obtain it from another side and say, well, Bruno, you were supposed to produce that to us and you didn't. I mean, what happened in this, I think there was also an inference that I violated a court order when in fact the opposite happened. If you look at, and I'm not sure if I could pull it up on my screen share. Is there any way I can get disconnected so I could share?
Is there a way to activate his screen share, Mr. Greer?
Yeah, let me do that.
Thank you.
While he's working on that, Mr. Bruno, what is your position on the standard of review that the board has in reviewing the Arizona disciplinary action?
I think the standard of review is a very tough one for me. I have to prove by clear and convincing evidence one of the defenses set forth in the statute, including an infirmity of proof, a violation of due process, that there wouldn't have been a violation under Texas law, or that, I think I forget one of the last ones, or that there's other just circumstances to not impose the similar discipline. But I think I can meet that standard of review. In fact, I have met that standard in review in front of the United States Court of Appeals for the 8th Circuit, who didn't impose any disciplinary action against me. But it's a tough standard. I acknowledge, which is why I'm asking this board. I know it's time consuming to go through the materials I submitted, and that's why I'm trying to give an outline of kind of where I would ask this board to look first.
Does the Eighth Circuit have the same standard?
It's very similar. It's hard to tell if it's the same. I mean, it's certainly as equally strict. I mean, it's kind of the same thing, due process and infirmary of proof. It's basically the same thing in all of the reciprocal disciplinary proceedings that I have gone through. It's a tough standard, and there's generally a presumption that the disciplinary proceeding from Arizona are correct unless I can show otherwise, or I can show a due process violation.
I think we've activated screen sharing. Please try again if you can.
Let me see.
Does the screen sharing seem to be working, Mr. Bruno?
Yeah, I'm working.
Oh, there we go.
How about now?
Yep.
And I'm just want to flip through here as soon as I figure out how. It's kind of hard because I got all these screens up. Bear with me, please. Okay. If you look through, this is just Exhibit 6, which is this was actually submitted to the court. How they handle things in Arizona, they kind of have informal discovery disputes, where you get the judge on the phone, and most of the times that issue is resolved. Well, before we had that discovery dispute regarding the production of draft reports and communications with expert, I submitted authority to the court. This is just one example of when I did so. And then what happened is the court entered and overruled my objections, and I complied with that order. The order is in the file. It's Exhibit 10. And I turned over the draft report and the information that I was found to have concealed. But I wasn't the only one who turned over draft reports and extra communications on that day. The opposing counsel turned over theirs, which they had not previously disclosed or placed in a privilege log. And they gave me about 2,633 pages of information. And I didn't.
Ms. Bruno, back to your response to request number 1. I didn't understand that you filed any or propounded any objections to request number 1. I thought there was some mention of a protective order, but there were no objections to that request. Is that right?
No, I don't believe so. What happened is, kind of when they were asking for stuff from my expert was years earlier. My expert and them resolved the subpoena amongst themselves, which I'll talk about in a little bit. And then a couple of years later, they served a subpoena on a separate one of my experts, and it was a different opposing counsel at this time. And I said, well, you're not entitled to expert reports or draft reports. And he said, no. So that's how this came to be. And then we went to the judge. The judge said, okay, well, if anybody has any expert reports or communications that they previously didn't disclose, go disclose them now. So in 2017, the judge ordered me to produce everything, which I did. I complied with that order. I didn't violate any orders. I didn't think about violating any orders. I raised an objection like I would do in any case, which I don't think is concealment or improper in any way, shape, or form. And then the judge overruled that order, and I complied. Now, that's not mentioned anywhere in the disciplinary court's determination. So I think that they were under the impression that for some reason I violated a court order, or I wasn't the one who produced this information, when these facts are undisputed, and I think actually stipulated to by the Arizona State Bar that that's what transpired. The second thing I would like to point out is the Arizona committee found that I wasn't responsive to a request for production, and that request for production elicited draft reports. Well, if I may go back to the screen share, here is the request for production. And if you look at it, it's one directional. All it requests is information from my client submitted to my expert. And what that was comprised of, because I talked to opposing counsel about it beforehand, is he wanted the underlying data to value the actual business that was in dispute in the lawsuit. Not only do I think the request for production is clear as day that it doesn't elicit draft reports, but there was 2 follow-up letters sent by opposing counsel, basically that asked for the same information, not draft reports, not communications, not things like that, that are in evidence before this panel. They were in evidence before the Arizona Disciplinary Board, but most importantly, the opposing attorneys, my opponents, testified in the disciplinary proceedings that that this request for production didn't solicit anything provided by my expert to my client or I, and that it was one directional, and that it did not elicit draft reports. So basically, the foundation for my concealment is a request for production that doesn't request this information. And one of the reasons I submitted the Arizona rule is because I don't think there was ever an obligation or a duty. And in fact, I think Arizona rules didn't allow for discovery of draft reports and communications with experts. Now, that rule has been modified slightly since, and now they make it expressly clear that you're not entitled to that information. And then finally, or not finally, but the one other big thing I wanted to point out is you have to look at the deposition related to the expert to see what happened. I mean, basically what happened is they served a subpoena on my expert, which I don't dispute solicited draft reports and communications with my client. But what happened is I initially got involved in a dispute between them what to produce, but then I washed my hands of it. And if you look at both my expert, who was called Timothy Downer, and opposing counsel's testimony on the stand, you will see that what happened is I washed my hands of it. They started working together related to compliance with that subpoena. And before the deposition, and all of this stuff is cited in my written materials, Mr. Downer, my expert, assembled what he said was his file and provided to opposing counsel directly. He didn't provide me a copy of that file, so I don't know what was in it. And then during the deposition, Mr. Downer tells opposing counsel multiple times, I have other things that I didn't provide to you. I have more stuff, including emails. And then they make an agreement on the record, and you could look at it. It's cited in my materials. I think like one of the last questions, if not the last questions, he asks them, or they make the agreement, and he says, well, I'll provide you all of the stuff that I promised to get you within 2 weeks. I'm going to provide it to you by FedEx. And then my opponent says, after you provide me this information, I'll give Mr. Bruno a copy. After that, it was a non-issue to me. I forgot about the whole thing because I assumed and presumed that Mr. Downer followed up with opposing counsel. What happened after that, I don't know, because the State Bar didn't present any evidence as to whether there was any follow-up, what Mr. Downer produced directly to my opponent. The only time I didn't know there was any issue related to this until literally 3 years later, when I was accused of concealing the draft report after I provided it in response to the court's order. So those are just a couple of things I would ask this board to consider. One of the things that I think all of the courts can consider in reciprocal discipline proceedings is whether or not there was adequate due process. I would allege in this case that there was clearly not, due to the fact that I was disciplined or the decision considered matters that were not charged against me. One of the things I was accused of was coaching my expert to lie or conceal the draft report in deposition, and that never happened in any way, shape, or form, and there is no competent evidence presented in that record to present it. Mr. Downer didn't testify to that. I didn't testify to that. There is no written communications or documents regarding that. But if you go back to the complaint, the disclosures, the discovery responses from the State Bar, their pretrial statement, and their pretrial memorandum, there is nothing indicating that they were charging me with concealing my expert to lie. In fact, one of my defenses was going to be that, hey, I never instructed anybody to conceal anything or lie in this case or any other. And at the State Bar's request, the judge issued a ruling in limine, which is Exhibit 3, which I'll try to get to here. Forgive me, I gotta find the right part. Right here. This is from the actual disciplinary judge. Right here on the bottom here of page 7, and I don't know if you could see my pointer, but the third line from the top says, nor does it appear that there is anything within the complaint that claims respondent directed anyone to lie, withhold evidence, or conceal information in this case or any other. So the disciplinary court made an express finding that there was no charge that I did that, and then precluded me from presenting any evidence on the issue. But yet, if you look at the actual order that came out, it's replete with statements about how I directed Mr. Downer apparently to lie or conceal information prior to the deposition. And that was used for all purposes to establish my intent, my motivation, and other things. That is a clear violation of due process under any standard that I can find, including under Texas, where I cited a couple of cases in my brief. If the state bar wanted to charge me with that, they should have done so, but they didn't. And it's even, I think the circumstances are much worse than they appear, because what happened in this case is the evidence that the disciplinary board relied upon was exclusively a letter from the state bar's counsel, from my prosecutor, saying that he had a conversation with my expert where my expert told him that I had concealed information. That is not credible or admissible or competent evidence. This letter was not sworn under oath by my client. My client actually didn't testify to that at trial, so it was inconsistent with this testimony. But more importantly, it all related to a matter which was expressly not charged in the complaint. And I don't think anybody can dispute that, especially with the disciplinary judge's finding in Exhibit 3, which I have presented.
Mr. Bruno, did you object to discussion of that letter or that evidence at the trial?
I actually filed a motion in limine, and I think it's ruled on in Exhibit 3 where the court denied that motion in limine. In fact, they said that, I think the state bar's position, well, we're only offering it for purposes of impeachment or prior inconsistent statement. And if that's true, you can't use that as substantive evidence that I engaged in a disciplinary violation. But even if you could, it doesn't matter, because that conduct was never charged. The first time that I knew I could be disciplined for that charge was when I actually read the disciplinary order that has extensive language about that allegation, which frankly never happened and wasn't true. It should certainly not be proved up just based on a letter from the person prosecuting the case.
Did the expert sign the letter? That was my understanding.
I think so. I think he signed it, yes. And then one more thing I'd like to talk about is the concealment charge. I mean, I got accused of concealing harmful information to my client. And I don't think this case presented the circumstances where that happened. So what happened, I tried to explain it previously, but basically the judge ordered a forensic investigation of my client's entire hard drives, 4 or 5 email addresses. And because of the hostility between the actual parties and proprietary concerns and privilege concerns and things like that, I was undertaken with the task to go through all of these files, and they weren't just files. You couldn't just pull them up very easily and they looked like a PDF document or a Word document. They were forensically pulled from the computer. So some of them looked like gibberish or gobbledygook, and others were different. They came out in different formats and different lengths. So it took me a long time to discern what they were and whether they were relevant. And then I had to prepare a privilege log, which is probably the worst part because we're talking about thousands and thousands of files here. I think I ended up producing about 2,300 to opposing counsel, and I held back about 900 or so. The specific numbers are in my response. But the opposing counsel, didn't make much of a challenge, if any, to any of my various objections. So there wasn't really any concern that I was concealing any of those documents. But that took me literally about 250 hours of my own time. I had to do it on nights and weekends and during vacation because I needed large blocks of time to go through this record. I couldn't get much assistance from my staff because you needed an intricate knowledge of the case, and you also needed to be able to establish what was objectionable and why not. And I did that the best I could. And keep in mind, no one had ever seen those documents. The only person who had ever seen them was me. So in compliance with the court's order, I gave them over to opposing counsel. And about 6 or 7 months later, opposing counsel filed a motion for sanctions seeking to dismiss the case based mostly on those documents, claiming that my client failed to produce them, he should be sanctioned, and his case should be dismissed. And that's exactly what happened. I knew that's what opposing counsel was going to do. I knew that those documents could prove harmful and detrimental to my client, but I produced them anyway without hesitation because that's my obligation to do so, and I was ordered to do so. I certainly wouldn't go through that all that time and effort to produce those documents, which I knew would be harmful, to conceal a draft report that I reviewed as a matter of course and didn't even remember prior to the lawsuit even being filed. That wasn't an issue to me. I still don't understand the significance of the language that was removed by the expert. And I certainly didn't do it on purpose or with any intent to conceal. And if I was trying to conceal it, I just wouldn't have complied with the court's order and I would have concealed it. I didn't even think about doing that. I was ordered to do something and I produced it. And finally, I would just ask the court to consider where we are in these proceedings. I was suspended in Arizona in November. I served that suspension. I served it. I was reinstated in May. I am on probation in Arizona. I have suffered extreme detriment and harm financially to my reputation, professionally. I have gone through various reciprocal disciplinary proceedings. I would ask that the court, that this board strongly consider, what the impact or what the benefit to the state of Texas is in suspending me at this juncture, because basically we're going to restart the process again. I'm not going to be able to begin to reestablish my reputation. I'm going to have to put my wife, my law firm, my employees through another suspension, and they've been pretty tolerable of me thus far, and no one has left me as of yet, but I don't know how far their patience or their limits will go. I have no disciplinary history in this state whatsoever. I have never been disciplined. I have never been sanctioned. I have been practicing law in Texas without incident since these events arose in 2013 or 2014, without probation, without supervisory status. So I don't believe that suspending me for 6 months to begin now and extend into next year serves any public purpose. Let me continue the practice of law. I routinely volunteer my time to teach seminars, including on ethics. I routinely participate in moot court competitions as a judge and things like that. I try to help those in need who can't otherwise afford to pay in full for attorneys, and I would like to keep doing that. I would like to be a positive influence on the profession. Trust me, I have learned my lesson regarding this case. I have been punished severely, and I'm begging and imploring this board not to put me through that again. If this board does think it has to impose any discipline, make it retroactive. The public will know about my suspension, but in the meantime, I could continue to do some good and aid the practice from a positive aspect. So I really don't have much more to add, but I would be happy to answer any questions that anyone has or submit any additional information that this board would like.
Mr. Bruno, what is the current extent of your practice in Texas?
It's basically none. Right at this moment, none.
Could you, if you're through showing exhibits, could you take off your screen share?
Yes.
Thank you.
Sure.
Does the commission wish to cross-examine Mr. Bruno?
No, not at this time, but I do have some comments.
I have one question, if I may.
Yes, Mr. Marine.
Okay, Mr. Bruno, thank you for being here with us. You said that as soon as you complied with the order of the judge to deliver the email to the opposing counsel, the case, that issue went away, right?
Well, no, it didn't go away. That's when it actually, what happened is opposing counsel filed a motion for sanctions against my client relating to all the forensic stuff that I produced. And then during that process, they filed a supplement that basically said, hey, well, we see that Bruno didn't produce this report. And then they started to go after me personally is basically what happened. And then it went to the trial judge and the trial said, well, I didn't do anything wrong related to the forensic examination, but I should have corrected my expert. I should have corrected my expert in deposition when he was talking about draft reports because the court believed that my client, or he wasn't my client, that my expert provided inaccurate testimony. So that's kind of where it all stemmed from.
Okay, and that was Judge O'Neill, right?
No, Judge O'Neill is the disciplinary judge. The underlying judge in the case was Judge Kiley.
Judge Kiley.
Yes.
And is he the same judge that filed the disciplinary complaint against you?
Correct. Yes, that was part of his order. That was basically his sanction to me was that I pay X dollars. It was about $6,000 to reimburse the attorneys for taking the deposition of my expert, which I did. And then as other part of his sanction, he filed a bar complaint. And that's one of the reasons why I think the complaint went as far as it did is because it was filed by the trial judge.
So it might be fair to say that in the eyes of the court, the issue was not resolved. The issue about the discovery.
No, the judge didn't think so at all. I mean, he clearly was mad and sanctioned me and filed a bar complaint against me.
No more questions. Thank you.
Mr. Bruno, do you have anything else?
I do not, but I appreciate everyone's time today.
Thank you. Mr. Berry, do you wish to respond?
Yes, I do. Under our rules, the judgment of a foreign jurisdiction is prima facie evidence that Mr. Bruno committed professional misconduct. In reciprocal cases, we don't really re-litigate, I can talk today, the facts giving rise to the misconduct in Arizona. Today, Mr. Bruno argues that there was a lack of due process and an infirmity of proof in the underlying matter, and I think he raised some issues regarding some of the, whether the rules were violated. I'd like to address some of the rules first. First, he talked, and I think he briefed this fairly consistently with Rule 3.3. In Arizona, it has a provision that the lawyer, the lawyer's client, or a witness called by the lawyer, if they have offered evidence that's false, that they have to correct it or take remedial actions. The Texas rule does not have that restriction on it. So under the Texas rule, he did have an obligation to correct his witness's testimony, and pursuant, it doesn't, if the misconduct in another jurisdiction constitutes misconduct in Texas, then misconduct, it has to fit into one of our rules. So it is misconduct in Texas for him not to have corrected the witness's testimony during the deposition.
Mr. Berry, isn't there a recent ethics opinion from Texas saying that a lawyer doesn't have the the duty to correct testimony if he did not elicit it? In other words, if it was on cross-examination?
May be right. I don't have that in front of me, but according to the rule, I can, do you know which number that is? I don't.
It's the either the last one or the one before.
Okay.
You don't need to look it up, Mr. Barry. You can.
Okay. No,
you can
that's
go on
fine.
without you.
I mean, I'm just saying that according to the plain language of the rule, he did have that obligation and didn't. I think the obligation to,
Ms. Barry,
yes,
I'm sorry to interrupt.
It's okay.
Reading 692.
692, thank you.
Yes, sorry to interrupt.
That's fine. I think it's uncontroverted that the request for production requested the correspondence, and that was not turned over. Whether you can consider not turning something over concealment, regardless of whether it was, and I understand that the pretrial order had the finding that he hadn't instructed anyone to conceal anything, but if you don't turn something over, if that's considered concealment, then 3.04 have been violated as well.
Mr. Barry, didn't the request for production only ask for documents that Mr. Bruno and his client provided to the expert, as opposed to things the expert provided to them?
That's true, and I would agree with that. And so it did not request the draft report. However, it did request correspondence from the client to the expert, and that email would have been correspondence that was requested in the request for production. So, yeah, our rule Arizona's 3.4D and our corresponding 3.04D are somewhat different. Theirs directly addresses this discovery. Ours just says if they habitually violate an established rule of procedure or evidence. So there are some significant differences in that rule, and I think it's a board's decision as to whether or not that rule has been violated by not turning over the requested documents at the time.
Let me ask you, Mr. Berry, is it the CDC's position that failing to produce a document requested in a request for production of documents is a per se violation of disciplinary rules?
Not per se. I think you would have to, if you didn't turn it over, you were obligated to make an objection and on the record. And I don't know Arizona's rules. I know in some jurisdictions, when you do that, you have to, at that time, provide a privilege log, just like you do in federal court. In Texas, you make the objection and then you provide the privilege log if it's requested. I don't know in Arizona how that rule plays out, but he was at least should have made an objection that there was, work product, something.
Has the CDC ever brought a complaint against a attorney for failing to produce documents in response to a request for production of documents?
I will say it has been part of some of the allegations against respondents, especially when they have habitually failed to do so after a motion to compel.
Right. In which there's been an order ordering the party to produce the documents. Isn't that right? That there's been some order.
Those are the ones that I'm familiar with, yes.
So I think it has to be more serious than just failing to produce documents. I think it has to be something else, like the failing to correct the testimony or misleading the court into believing that something's been produced when it hasn't been produced, or maybe misleading counsel. It's just not the fact of failing to produce a document that would result in a grievance, right?
Generally speaking, you're correct. Or at least to my knowledge, we haven't pursued one. I wouldn't say we never have. I have not. Okay. I think 8.04A3, our 8.04A3 is exactly like Arizona's engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. I think that Mr. Bruno's comment to opposing counsel that the subpoena was unnecessary because they already had everything was very definitely a misrepresentation, because it specifically asked for things like the draft report that had not been asked for in production. So it's clear he knew they didn't have the draft report, and yet he tells them they already have everything they need. We will concede that 8.04D or their 8.04D and our 8.04A8 are not the same rule violation, and we would not include that as a rule that the board should consider. The conduct does not rise to the level of obstruction of justice, which is what our rule requires. I think the decision order dated October the 9th, I know Mr. Bruno went into that they wouldn't consider mitigation, but the decision order of October 9th actually indicates in paragraph 4 that they did consider both aggravating and mitigating factors when they determined the sanction. Let's see. If the board determines that Mr. Bruno has proven any of his defenses contained in Rule 9.04, then the board should determine the appropriate sanction to enter. Any more questions?
No, thank you, Ms. DeBerry. Mr. Bruno, would you like to respond?
Yes, if I may, please.
Mr. Marino, I kind of hate to have you guys tag teaming Mr. Bruno, but if you have a brief remark, I'll let you make it. But
I do. I have just a brief remark regarding the October 21 opinion of the Texas Committee, just really brief.
okay.
It was a question of the board, one of the board members. I think it should be answered.
Okay,
May
go
I?
ahead.
Well, actually, that Texas ethics opinion of October 2021 actually says at the very end, under the Texas Disciplinary Rules of Professional Conduct, a lawyer does not have a duty to correct intentionally false statements made by the client while being cross-examined by the opposing parties counsel during a deposition, where you have to go far and read. Nevertheless, the lawyer should urge the client to correct the false statements, including by explaining the potential civil and criminal ramifications of false testimony. If the client refuses, the lawyer may, but is not required to, withdraw from the client representation if permitted by the rules. That, in my opinion, goes hand in hand with Rule 303B that says if a lawyer has offered material evidence and comes to know of its falsity, the lawyer shall make good faith effort to persuade the client to authorize the lawyer to correct or withdraw the false evidence. I just wanted to bring that up to the table.
Okay, thank you. Mr. Bruno,
Thank you.
your response?
Thank you. I appreciate Mr. Berry's comments regarding the Texas rule and the Arizona rule regarding it 3.3, but I don't think the characterization is a fair one. When this deposition took place, I was in Arizona. I'm bound to the rules of the jurisdiction in which I'm practicing at that time, which generally isn't a big deal, but I've probably practiced in 12 to 15 jurisdictions over the course of my career. So I'm bound to keep in touch with or know the rules in the jurisdiction where I'm practicing. And I think Mr. Berry conceded it, but under the circumstances presented, I didn't have a duty in this case. If you look at Arizona's plain language, it says if a lawyer, the lawyer's client, or a witness called by the lawyer has offered material evidence, and the lawyer comes to know of its falsity, the lawyer shall take remedial measures. My duty wasn't triggered there. It wasn't, Mr. Downer was not my client. He was not a witness called by me. And I wasn't soliciting any questions at the time. This was stipulated to by the state bar and I. So under the plain language of that rule, it wasn't violated. If I was in Texas or another state where it extended that duty further, then my conduct may have been different. I mean, frankly, I didn't ever realize there was a material misrepresentation. So I don't know what I would have done, but I don't think I had any duty in Arizona at that time. And then I think a couple of the board members touched on it, but I think Arizona got the cart before the horse in this case. I mean, if you look at the cases from Arizona that I cited in my response, that frankly the state bar cited to disciplinary, the applicable cases all involve a case where an attorney didn't produce information after an order to compel. They skipped a step with me. I was essentially sanctioned because I complied with an order after I objected to, and I don't think that's fair or appropriate, and it's certainly not evidence of concealment. I didn't have any intention to conceal it. I did what I was supposed to do. I had a valid objection. I was trying to protect my client. I was trying to go by how I interpreted the discovery rules at the time. I presented my case to the court. I was unsuccessful, and I did what I would do in every other case after raising an unsuccessful objection, which is I complied with the court's order promptly and timely. And finally, there's some indication that my letter to opposing counsel indicated that we had already produced everything related to the expert. That's because I thought that was true. This wasn't a case where me and opposing counsel, at least initially, were adversarial. We were actually very, very friendly to each other and communicated constantly. We had an agreement that neither party would produce expert communications or draft reports, but you don't have to take.
Mr. Bruno, was that was that disputed testimony?
That was disputed. Opposing counsel disputed that testimony, but my word doesn't have to be taken for it, because look what happened. After the court ordered both parties to produce their files, the opposing counsel produced literally 2,600 pages of information that not only did they not produce previously, but they didn't produce a privilege log in any form or fashion. And under Arizona rules, you have voluntary disclosure obligations. So if you're withholding something that needs to be disclosed, you have to do a privilege log or disclose that fact. I acted in the same manner as opposing counsel did, but I got zinged for it. And nothing happened to them. And I'm not saying that's wrong. I'm just saying that there was reasons why we acted the way we did. And then to go beyond that, if you look, I gave up that fight. My expert was sitting there telling opposing counsel, I have emails to you that I didn't produce. And then they made an agreement on the record in front of me that I didn't interfere with or obstruct in any form or fashion, that whatever my expert didn't produce at that time, it would come within 2 weeks after the deposition. That's right in the record from the deposition. So again, you don't have to take my word for that. I didn't know there was a problem or an issue until somebody accused me of concealing this draft report in 2017. So that's all I would have, but I appreciate everybody's time today.
Can I respond just briefly?
In just a moment, does the board have any questions for Mr. Bruno?
Mr. Bruno, Michael Gross, I just wanted to clarify something with you, because I don't want to get it lost, forest for the trees. Under 9.04, what defenses are you urging specifically?
The biggest ones under 9.04, and if you forgive me, let me read back to the rule, but are the due process violation.
What is it you claim violated your due process?
I claim there are two. The state bar, the disciplinary authority clearly considered conduct related to my alleged instructing my expert to conceal the report in their discipline and in their sanction. That conduct was never charged. I had no notice that that was a charge or I could be disciplined for it. That is a violation of due process as I read the case law.
So that's unfair surprise to you?
Yes. The second one, It is an expansion of ER 3.3. What I think happened in this case is there was a couple words it placed into ER 3.3, which is basically an expert of a party or a witness disclosed by a party to impose a duty upon me to correct the testimony of my expert during that deposition that does not exist in the plain language of the rule. And I've cited the cases about how if something is in a rule, it's presumed that everything else is excluded and admitted. So I think those are the two.
Let me stop you just 1 minute
Sure.
there. So on the due process with unfair surprise, did you request time to prepare for that?
No, because I didn't have any time to prepare for that. I didn't know that the charge that I concealed an expert report could have any disciplinary actions against me until I actually got the decision.
Okay, and then after the due process, what are the other defenses under 9.04 you're raising?
There was an infirmity of proof establishing the misconduct.
Okay, and next?
I don't think the grave injustice one is really valid. I think that contemplates something else. I think the misconduct warrants substantially different discipline in this state, if any is found, especially since any misconduct that this board finds would need to be considered, as well as the sanction independent of the stuff about the charge related to the concealment of the expert, which frankly, I think was the only thing that was really egregious in that case. I mean, I think that's why it was added.
Thank you, sir.
Oh, and my other one is the last one, subsection E, that the misconduct for which I was disciplined does not constitute professional misconduct in this state.
Just what, from your perspective, Mr. Bruno, what are the lessons learned, or what are you telling people about this case, and what to do in the future and to avoid something like this ever happening?
I'm telling them to insert their objections. Well, number one, I'm saying make sure they produce anything and everything. I've specifically changed my practices basically to be more proactive on a privilege log about disclosing things, particularly expert communications or expert reports. I'm generally giving disclaimers in the lawsuit that, hey, we have draft reports or expert communications, but we're not producing them under rule whatever. Those are some of the things. I'm making double and triple certain that everything we have in our files, because sometimes it gets confusing, especially with emails and redundancy nowadays, are actually being produced by us to the opposing counsel. And I'm paying a little bit more attention and being a little bit more proactive nowadays in depositions, just to make sure if there's any question about whether something is coming out right, regardless of who is saying it, unless it's opposing counsel, that I'm doing something to make sure there is no confusion or inaccurate testimony that is remaining on the record. Those are some of many things I'm doing, but like I said before, I have learned my lesson very harshly.
Any other questions for Mr. Bruno?
I'm sorry, Mr. Mateo.
Yeah. Mr. Bruno, I just have one question. When you answered Mr. Cleveland, you said one of many lessons. And what else? You gave a list. What else in particular are you doing that's changed after this matter's taken place?
I also have a standard form letter that I created that spent a very long time talking about disclosure requirements, depending on the state. Nebraska doesn't have a voluntary disclosure requirement. So, for example, in Arizona, I've prepared a pretty extensive letter talking about the disclosure requirements, outlining the parameters of rule, and most importantly, telling clients that, hey, you have to search everything you have. You can't just produce things that you think are favorable to your case. Anything even remotely related needs to be produced the other side. And you're not the judge or the court. If we think there are valid objections, we will assert them properly, but we have to have full disclosure to the other side. And I could tell you that I have been chasing down clients who were basically giving me documents in batches from sources. You know, I'm way more proactive about, hey, you need to identify all of your electronic devices, computers, and we either have to produce everything that's on them if we can, or we have to disclose that there may be relevant information on these certain things. Those are just some of the things. I mean, I thought I always did a pretty good job of producing everything and complying with orders, but now I'm gonna take the extra step because I don't want to go through this again.
Okay, Ms. DeBerry, your response?
Yeah, just briefly, his argument about the lawyer's client in Rule 3.3, I believe looking through the documents and the judgments that basically Arizona found there was constructive, that the expert was his constructive client because he prepped the expert for the deposition ahead of time. Also today, he's called the expert in this hearing his client and his expert. He's referred to him both those ways. Regarding the no notice of concealment rule, he was given notice that in the complaint that he had violated 3.4A, and 3.4A does have the word concealment in it. It may not be in the facts that were alleged, but it is in the rule violation alleged. So that's all I had. Thank you very much.
May I make one comment?
Yes.
Me calling my expert my client was just a slip of the tongue. I think the stipulated facts in the Arizona proceeding established that Mr. Downer was never my client.
Thank you. Anything else from the commission?
No, not at this time. Thank you.
Anything else from you, Mr. Bruno?
No, thank you again.
Thank you both for your excellent briefing in this case and your argument. It's very helpful to us. Appreciate your patience, and we will take this under advisement, and you are dismissed. This will conclude today's proceedings before the Board of Disciplinary Appeals, and we are adjourned.
Thank you.
If the board members will sign into the link for deliberations.